Namaskar, welcome back to Media Scan. Viewers, the DMK, Congress and few of their allies have moved an impeachment motion calling for the removal of Madras High Court Judge Justice G.R. Swaminathan. Their charge is that the justice has been giving verdicts which are influenced by political ideology and he is compromising the secular principles of our constitution. The Home Minister has accused the opposition of weaponizing the impeachment motion and calling it purely driven by vote bank considerations. So, on Media Scan this weekend, is the opposition weaponizing the impeachment tool, and is the judiciary under attack because some orders are not favorable to one or the other party? We have law-knowing persons, well-known legal personalities to help us understand this subject. But before that, a quick report.
The impeachment motion against Justice G.R. Swaminathan of the Madras High Court has become a full-blown controversy. It also rocked Parliament this week. The DMK, Congress, SP, Shiv Sena, Uddhav Thackeray and others have accused Justice Swaminathan of giving verdicts based on ideology and anti-secular leanings. Justice Swaminathan had ruled in favor of the Karthigai Deepam ritual on Thiruparandrum hill by Hindus. The ritual was disallowed by the Tamil Nadu government, citing law and order concerns because there is a dargah close to the site of the Deepam. Despite the court order, the state government stopped lighting of the Deepam at the site.
आजादी के इतने साल में नहीं हुआ है मान्यवर कि कोई जज एक जजमेंट दे तो जज के खिलाफ इंपीचमेंट लेकर आते हैं अपनी वोट बैंक को एड्रेस करने के लिए इंपीचमेंट लेकर आते हैं मान्यवर.
So, with those strong words of the Home Minister Amit Shah, let me introduce you to our guests for this evening. I have here with me Mrityunjay Singh. He is an advocate practicing in the Supreme Court. He is also attached with the legal department of the Congress Party. Namaskar, Mr. Singh. Also with us,
Namaskar.
Ramakant Gaur, another senior law-knowing person. You have been listening to him on Media Scan on previous occasions. Namaskar, sir. Good to have you.
Namaskar, Smita ji. Thanks for having me.
Very soon, we will be joined by another senior person who is also from the legal fraternity. But right now, I'll come to Mrityunjay Singh first. Mr. Singh, I think the opposition and everybody else who understands the parliamentary procedures knows very well the opposition is far, far short of the numbers which are required to carry through a motion like this. Now, the question is, since it is well known that the motion will not pass the muster, the numbers at all, is it wrong to say that this political move was just optics, just meant and targeted at a certain section of the society, a vote bank to whom you want to just give a message that, look, we are here for you, knowing fully well that this impeachment will not see the light of day?
First of all, I would like to say that so far as history of judicial impeachment is concerned, it goes back to the year 1993, when Supreme Court Justice J.V. Ramaswamy proposal was initiated for impeachment. And similarly, in the year 2011, when Congress Party was in the government, similar proceeding for impeachment was brought to the Parliament against a sitting Kolkata High Court judge. So far as these judicial proceedings are concerned for their removal, it is the only way out, and that is the only check and balance which has been deliberately provided in the Constitution of India. If you go by the provisions of Article 217 and 18, it says that so far as removal of the High Court judges is concerned, a proposal may be brought to the House of the Parliament for their removal. So if a political party or certain political parties say they are aggrieved by the conduct and the verdict or the judgment which has been pronounced by the honorable judge of a particular high court, they are well within their right to initiate this proceeding.
No, Mr. Singh, you have given a very good account of what happened in previous impeachments, at least one of those which you mentioned, of the Calcutta High Court judge. I am witness because I covered those entire proceedings myself.
Yes.
And both sides of the House were agreed that this impeachment must go through, but then he resigned finally in the nick of time. What you haven't answered, Mr. Singh, is the opposition, including the Congress party, the DMK, has been knowing fully well that you are far short of the numbers required for this impeachment to go through. Why then just create a photo op, except for vote bank considerations? I just need a straight answer to that, if you have.
Yes, it is more than what you say is a photo op. See, once as a responsible political party of this country, when you get to see that there are judgments which are being passed by a particular judge from a particular point of view, or one may say that particular ideology, which is not in conformity with the constitutional provision. So they are right way, and they are well within their limit to raise this issue in the House of Parliament, in the either House of the Parliament, and that is why they are doing this. And so far as numbers are concerned, we do not know whether it will proceed further or not. But then, when there is a wrong and there is a remedy provided in the Constitution, all the parties who have signed this petition have rightly done so.
Fine. Point taken. We'll come back to you on that. At the moment, as we would like to tell our viewers, the motion for impeachment lies with the Speaker's office. He is examining it, and we'll get back to the House as and when he takes a call on it. Just to remind our viewers, to get this impeachment motion through, it needs a minimum of 100 signatures for the Lok Sabha, which has already been provided. There are more than 120 signatures at present in that motion, moved by the DMK and Congress. However, to get it passed in the House, the minimum required number is half of the total strength of the House and 2/3 of the present and voting, which looks like a tall order for the opposition, if at all it comes to the House. But I want to come to another friend who has joined us just now, Aman Sinha, another law-knowing person from the legal fraternity. Namaskar, Aman Sinha, good to have you. And I'll come to you, Mr. Sinha, quickly. You heard Mr. Singh make his point just now. The question here is that there is a legal remedy, as Mr. Singh has said. Whether the numbers add up or not is for the House to decide as and when we come to that step. Before that, if they want to exercise this remedy of trying to question the decisions of the judge who they think has been compromising the secular credentials of our Constitution and giving verdicts which have an ideological slant, what is wrong? Why call it vote bank consideration? It is a legal remedy provided in our Constitution.
Smitaji, let me start off by saying that judiciary serves as the guardian of justice and rule of law in our country. And the dangerous trend which is emerging now is that there is a systematic effort to undermine the judiciary whenever the decisions coming out from judiciary do not favor a particular political party. There is an attempt to undermine the judiciary and pressurize them. And this has been happening from opposition parties led by Congress from quite some time, especially in the recent past. And as you have said, this is a constitutional mechanism. The mechanism of impeachment is a constitutional mechanism. It cannot be weaponized to be used as a tool to either pressurize or attack the judiciary. As you very aptly put this query that when there are no numbers to push this through, and certainly I would also gather that there is no proven misconduct or behavior, which are the cogent grounds under Article 124(4). Therefore, there should not be any impeachment moved at all. The only sole purpose in my assessment is that this is weaponization of impeachment just in order to pressurize the judiciary whenever the decisions which come out from judiciary are not serving their political purpose. The opposition and other, their allies are attacking and undermining the judiciary. This is what is happening. The same thing happened in case of Justice Shekhar Mishra also from Allahabad High Court. So there are numerous such, repeated instances. And Congress party, it has a checkered past when during the times of emergency, it superseded large number of judges of the Supreme Court and got their own favorites anointed them to the top positions in order to get favorable judgments. It is ironical and hypocritical that today they are questioning the judiciary at such instances. I would also like to add,
we'll come to the background. I am just reminded that perhaps it was during the emergency for the first time that the country heard the term committed judiciary, whatever it was supposed to mean. But allow me to come to Mr. Gaur, also here, your colleague from the legal fraternity. Ramakant Gaur, for the past 2 days, I have been reading up and studying about it, and a lot of retired judges, senior legal luminaries have written that this impeachment, which is not mentioned in the Constitution, the process for removal is mentioned, but this process of what we call impeachment in common parlance is a very unusual, it is a rare tool, and it should only be applied when there is serious misconduct or a case of very serious impropriety. Otherwise, it will become very difficult for the judiciary to remain independent. Your first thoughts on the moving this impeachment motion for Justice Swaminathan?
My first thought, Smita ji, बगल में लाल किताब संविधान की रखकर आसमान में कूड़ा फेंकने वालों को ये याद रखना चाहिए वो कूड़ा उन्हीं के मुंह पर गिरता है. This judgment passed by the learned judge was nothing but reiteration of the proceedings which was held in original suit of 4 of 1920. So 1920 suit, which was upheld by the trial court in 1923, went up to Privy Council. Privy Council upheld the rights of the Hindus to let this Deepak. 1994 Madras High Court judgment is the same. So if somebody has read this judgment, they would not have pointed it out like such a serious case of impeachment. So if they know nothing about the Constitution, they know nothing about the facts of the case, and they are simply making hue and cry, then have pity on them. Amanji says one thing, that it is the history of Congress government. Keshwanand Bharati's case is not forgotten in history. ADM Jabalpur case, which has scuttled the pathways of Justice H.R. Khanna to reign as a Chief Justice of India, we have not forgotten. Umpteen number of judges of Delhi High Courts were transferred because of the facts that they did not pass any favorable orders, stroke judgments in favor of the then government. It's a matter of record. One of their own ASG at that time, Mr. Nariman, wrote in his book that this was a black era. So, emergency, we have not forgotten. Now, 3 more judges of Allahabad High Court were again superseded that time. So we have witnessed all that. We have not forgotten the merit riots. We have not forgotten 1984 riots. The victims could not be given justice because of the connivance of the then government. So they have always been trying to assail judiciary or dominate judiciary. They may not be succeeding in that. Judiciary is that powerful. If they were aggrieved by this judgment, they would have come to Supreme Court.
No, but they have come.
They not to.
Yes, they have come, and it has been admitted. We'll wait to see what the Supreme Court finally decides. Yes,
that was the only recourse.
You have made some very serious charges also, Mr. Sinha. So I want to come to Mrityunjay Singh here. Mr. Singh, first of all our two friends here have said very clearly that the Congress party has a very, very checkered record when it comes to dealing with the judiciary, right from the early 70s to the present. But even if I look at the current case here of this Karthigai Deepam, the judgment that was, the verdict that was given by Justice Swaminathan, it went to the division bench also. In fact, the state government went to the division bench. The division bench upheld the verdict of Justice Swaminathan. Even then, the state government, they gave other reasons of law and order, etc., and stopped the people who wanted to observe the ritual of the Karthigai Deepam. So things are really muddled here. What is your answer?
See, Parliament is the custodian of constitutional mandate.
Why don't you wait for the Supreme Court to give its final order on this, if you are aggrieved with the order?
Because there is a remedy provided in the Constitution itself that a High Court order can be challenged before the Honorable Supreme Court by way of filing an SLP. So that is one remedy. So far as challenging the legality of that order is one aspect. Another aspect is the conduct of the Honorable Judge, who has been passing orders in a particular manner or a particular fashion, which is detrimental to the basic structure of the Constitution. And that is why the certain political parties have decided to come together and initiate this proceeding, where you cannot overlook the fact that more than 100 honorable members of Parliament have signed this motion. So you need to also understand from their point of view that they are representing different states, different legislatures, different people. So they are also accountable. And when they see that there is something which is not according to the Constitution happening in a particular High Court or by a particular honorable judge of that High Court, they are well within their right to raise this issue. And it is just a beginning. It is initiation. See, it goes through 6 process. It is initiation. 100 MPs have given their consent that yes, they agree that this order passed by the honorable judge is not correct. It will go to the honorable speaker for admission, and if admitted, there will be an inquiry committee, 3-member inquiry committee constituted, comprising of High Court and Supreme Court judges. So let's wait for the outcome. Don't jump that merely because there is a proceeding or there are allegations against the judge who has obviously written something which is not appropriate.
Which paragraph of the judgment are you referring to which is unconstitutional?
So before we go to stage 3, it is too early to say that it is a political step, or we need to stop looking it from the political prism.
Okay. Aman Sinha wants to come in here, but I'll leave one question with you, Mr. Singh. I'll come back to you. The counter question to your argument is that there may be 6 stages or even more. But the point is, if you start bringing impeachment motions like this, it will have a chilling effect on the judiciary, because every time a judge gives an order, he or she will be thinking whether it will create an impeachment process or what. But anyway, I'll allow Aman Sinha here. He wants to add something to your point. Aman Sinha, quickly make your point. Then I want to come to another observation made by the CJI, Justice Surya Kant, also this week, which is also, in a way, an attack on the judiciary. Quickly, Aman Sinha.
Smitaji, we all know that legality of judgments or not being agreeable with a judgment can never be a ground for impeachment. There are, legal and constitutional procedures for that. One can go up to appellate court. My learned friend was himself advising that we should not be jumping the gun and we should wait. So what is the tearing hurry? They could have waited, and as I mentioned to you, if somebody disagrees with a judgment, they are entitled to do so. But that does not become a ground for impeachment under 124(4). There are only 2 grounds which are there. One is proven misconduct and other is misbehavior.
No, as far as misconduct is concerned, they are citing that he has been unduly favorable to certain lawyers. So that shows a partial attitude.
I do not think, there has been any such inquiry from which such observations have come through. Any judgments of any appellate court which have opined so. In fact, on many instances, all his judgments would have been put to challenge, would have withstood the judicial scrutiny of the higher courts. So therefore, and there is no such remarks which has been made against this particular judge by the higher courts, by Supreme Courts or whichever court which is sitting in appeal. So therefore, these are all absolutely unfounded, baseless. And this is what Constitution cautions us against, that there has to be proven misconduct or misbehavior. There has to be substantial evidence or body of evidence for it. There's nothing of this sort in the public domain. And therefore, just on mere conjectures or perceptions or being disagreeable with a particular judgment or a judgment not serving your political purpose cannot at all become a ground for impeachment.
Fine, fine. I'm sure there is more to it. Already, we hear the chatter in the parliament has been that even those who moved the motion are not very hopeful about the fact that it will go through, but they thought that it was good to, take that step for other reasons, for reasons of narrative and optics. But coming to you, Mr. God, there is another very serious observation, none other than the CJI Justice Suryakanth himself. And this is in reference to many petitions, dozens of petitions with regard to the Rohingyas and other infiltrators who are here in our country. And the Justice, the Honorable CJI has been saying that there are repeated attempts which are meant to pressurize the judiciary. One petition after another is filed sometimes by activists, sometimes by political workers, demanding facilities and other things for these infiltrators, and then pressurizing on the question of refugee. We all know very well, our viewers are also aware that India is not signatory to any convention on refugees. So why do you think the CJI had to make such an observation, such an impassioned comment? Is it because the judiciary is really getting, flooded by petitions even after they have given their opinion?
See, someone hurls shoe in the Chief Justice's court a few months back. Scurrilous allegations from all sides. Whosoever is aggrieved make scurrilous allegations. Social media is inundated by such comments, and poor judges, poor honorable judges who are supposed to be the most powerful persons who are deciding the law of this country cannot say anything on their own behalf. That's the agony. And that's why Honorable Chief Justice had to say this. The courts are, if you look at Justice Pardiwala's impeachment attempt or other attempts by the opposition, they are what? They're simpliciter assault on the judiciary. And if such assault is not dealt with the iron hands, then it will continue.
Okay.
You are maligning the institution. You are not saying against a judge or a particular limb. Entire judiciary is under attack.
Fine.
Some bureaucrats gets up and says there are vacations without knowing the nuances of the judicial system. Another journalist says pendency of the cases. All right, but please look into the statistics. Their problems, their infrastructural issues. Nobody wants to address that. And the judges cannot advocate for themselves. They cannot put forth their stance.
Yes, those are really matters of concern. Another important matter of concern that has been, repeatedly making headlines, and I'm sure the legal fraternity is seized with the matter, is this whole, this whole game of forum shopping, bench shopping, as they say. The CJI has been concerned with that. And the CJI who just gave up his position and handed over to Justice Suryakanth was also worried about it. I will also come to that, but very quickly, Mrityunjay Singh, do you want to add anything on the question of the Madras matter? My specific question to you is, if the numbers are any indication, this impeachment motion is going to stay here. It is not going to go any further. In that situation, are you satisfied with the photo ops or do you have plan B in mind?
So far as impeachment proceedings are concerned, it is only on 5 occasions in the past 70 years of history of Constitution of India is concerned. Only on 5 occasions, the impeachment proceedings were brought against different judges at different point of time.
Fine.
And it is not that all these proceedings were initiated during NDA-led government. It was also during the Congress-led government. So far as judges are concerned, they are not above law. If they are caught doing something wrong, there is a provision in the Constitution, and they must feel afraid of the provisions of the Constitution, that if they do something which is wrong or contrary to the provisions of the Constitution, they will face the music.
I think the feeling afraid of idiom is the real trouble here. But since we have very little time left, not even 2 minutes, Aman Sinha, quickly, you want to react to that very quickly, sir. Secondly, what are your thoughts on this whole concern over forum shopping? The learned judges have been speaking repeatedly about it, trying to bring mechanisms to ensure there is no forum shopping by some powerful people in your fraternity.
No, Smitaji, that was a telling line. Judges to be not afraid of or to be afraid of, because that itself tells a story. We don't need to elaborate much further on that. But as far as the allegations of forum shopping are concerned, very clearly in the Constitution, the Chief Justice is the master of roles,
Yes.
Chief Justice of India for the Supreme Court and the Chief Justice of respective High Courts for their own High Courts. And this has been now settled in a recent 2018 judgment where I had the occasion to appear for Supreme Court Bar Association also, and where Justice Deepak Mishra was then Chief Justice. And we would recall the story when there was a press conference by 4 other judges of the Supreme Court. In that particular matter thereafter, which was taken up, the Supreme Court has categorically decided, it's a larger bench judgment. They have decided that the Chief Justice of India is the master of role and has the prerogative on listing of the matters. So therefore, that should end any debate at all on the issue of master of roles. And whichever matters which are filed, they should first be going to Chief Justice. He allocates the work. And very recently, as you also just flagged, Justice Suryakant has come up with certain new rules, Supreme Court
Yes.
rules, whereby the mentioning procedure has also been streamlined. This is from the system of oral mentioning. We are moving towards a system of written mentioning, and matters will get listed within 2 days.
Okay.
And so therefore, that makes for a much more efficient, transparent system and a much more justice-oriented system, much more equitable system.
Let's hope so. Ramakant Gaur, just one line for you. I'll give you the last word. Are you hopeful that forum shopping will hereby end and the system will become much more transparent and no pressures about benches anymore?
See, it will never stop, irrespective of the fact that there are certain judgments, but whosoever will have convenience and suitability will go and find the cases there only, like Punjab government is doing certain registering certain cases in Punjab. They did it in Delhi. So whosoever government is there in the power, or whosoever litigant is in the position to avail a particular jurisdiction, you would love to go to that court or agency.
Fine. I think we'll have to stop it here, gentlemen. This has been a very informative, very engaging conversation, but there's no time left at all. The crux of the matter is that whether it is through impeachment, through forum shopping, through repeated petitions, even when orders have been given very, very clearly, all these shows somewhere the judiciary is under attack, or at least being put under pressure, if not under attack. But on that note, let me thank Ramakant Gaur, Aman Sinha, Mrityunjay Singh, all 3 of you gentlemen for sharing your thoughts and perspective. That's a wrap up on Media Scan for this weekend. Do join us next weekend. Namaskar.
Thank you.